Hey, everybody. My name is John Waite. I'm a partner with Martin and Gifford, which is a law firm in Winston-Salem. We are general counsel to NC Realtors, and I am here today for this Mobile Monday to give a rundown and some background and context to the antitrust jury verdict that occurred in Missouri. I guess that was a couple weeks ago now. I want to start just by being very, very simple. Okay. So let's just talk about antitrust and what that means. Okay. Because a lot of times I think the word gets thrown around kind of like a boogeyman or whatever, don't antitrust this, that, blah, 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 avoid antitrust. So let's just talk about the history of it just briefly. Okay. Back in time, in our country's history, there used to be these conglomerates, these large companies where they controlled every aspect of a market. So, for example, there's one company that owned all the oil, Standard Oil, right? There used to be one bank, essentially, and that's, JP Morgan used to be essentially the only bank or the biggest bank. There used to be a bank big enough to monopolize pretty much everything in the banking industry, et cetera. Okay. And then what happened is the Sherman Act was adopted in order to break up these big companies, which go by the name of trust. So that's why antitrust is named as it is. It's not a trust fund. It has nothing to do with trust accounts. It has nothing to do with that. Trust is just an old term for these sort of big conglomerate companies where they would get so big and so powerful that they would be able to monopolize a particular industry. More recently, some of you may remember in the 1980s, Ma Bell, used to be a giant phone conglomerate. And then the Department of Justice came in and broke it all up into bits and pieces. And those bits and pieces still exist today and float around and, are separate companies in and of themselves. So that is the context that we are in. Okay. So when I say antitrust, that is what I mean. It is that the Missouri case is about an allegation from, in this particular instance, sellers, saying that the way the MLSs function was an antitrust violation. Now, in order to be an antitrust violation, you don't have to be so big that you control, everything in an industry. It can be localized. And that's kind of what happened in Missouri. In the Missouri case, what happened is some sellers who are part of a certain part of Missouri, in and around the Kansas City area, they found a lawyer willing to take their case. And basically what they alleged in that case was that the way the MLS works, and in particular, this was the real crux as far as what the plaintiffs relied on in that case regarding MLS rules, was the blanket offer of compensation. And just the fact that that in order to list property, there must be a unilateral blanket offer of cooperative compensation stated as a dollar amount or a percentage, right? So the plaintiffs used that rule and used data from the market to show that the rates of compensation were too similar in order to allege, and what the jury eventually awarded, an antitrust violation, saying that though the rule, in conjunction with some other factors that I'm going to talk about today, that the combination of the things created an environment where a trust existed and violated the Antitrust Act. In Missouri, what they alleged a lot of different things, but ultimately what the jury considered was the Sherman Act, which is a federal law. Well, most states, I think nearly all states, have their own versions of antitrust statutes. Ours are the Unfair and Deceptive Trade Practices Act. So if you want to know where North Carolina's is, it's in Chapter 75. So that is essentially, that's sort of a nuts and bolts of how the Missouri case got, and just explaining it that way may be making your head explode, just a little bit. For example, you may have a question of, how can it be that, there's this alleged conspiracy to, fix prices? How can it be that us doing a normal transaction, the way we do them in the MLS, how can that be a violation? I'm going to talk a little bit more about that as well. But if that is your initial reaction to me, telling you what the basic facts of the case of Missouri are, then I think that you are, a lot of people are asking the same question. So don't feel like you're crazy. Don't feel like, it's confusing. It just is what it is. And for that matter, please, I just have a simple request today. Please don't shoot the messenger. I'm not going to sugarcoat anything today, but I'm also not going to tell you anything that I haven't actually read as far as what was part of the case. And understand, the way trials work is you go and you do discovery, right? You ask for documents, trade documents. Trials are a long process. You file the lawsuit. In this case, you're talking about a class action, but the class was small. You're not talking about a national class. The class was just in and around, the Kansas City, Missouri area. So that was the class that was established for that particular case, and that's where the damages came from. So you can imagine that, if $1.7 billion was awarded by one jury for one part of Missouri, then, the stakes are relatively high if you look at what the potential damages could be across the country, which will get me into a discussion of what kinds of cases you may be hearing about coming up next. And I'll talk a little bit about a case in Texas. So back to the function of a trial, though, there's a complaint that's filed, okay, and that has just allegations, and that's exactly what it sounds like. They're not proven, okay, they're just allegations. Plaintiff files that, and in a class action suit, then the plaintiff has to also prove that the several people who actually are the plaintiffs represent a larger group of people. It's called a class certification, okay. So that happened in this case. In this case, a couple of sellers filed. They certified the class. And what were the allegations in the complaint? And this is what's really, really important, I think, for you guys to understand, is what the essential allegations were. Now, if you don't remember exactly what I say right now, don't feel like you have to rewatch this video or anything like that. When NC Realtors published a summary of the Missouri case on their website last week, or it actually is the week before that, I think. In any event, there's an FAQ on the website, and I go through some of the allegations that were in the Missouri case, some of the things that the plaintiffs are alleging. And in that case, you went from allegations in a complaint all the way through an answer where, the National Association of Realtors and the other defendants were able to file their responses, make arguments such as cooperating compensation, benefits, parties to the transaction, all these arguments that you guys, would make in your own head about, how is using the MLS creating an antitrust problem, right? You have, arguments in your head. Maybe you have heard things over the years from the National Association of Realtors, maybe in your antitrust training, things like that. You would have these arguments that you would make to say that there's not some sort of antitrust violation here, right? So those were all presented. And what happened is that, the judge didn't throw out the case, and the judge put the case to the jury. The jury in Missouri, deliberated for about 2 hours before delivering the verdict. Okay. So not a long deliberation. So what did they look at? What allegations were in the complaint, and what evidence was presented, in that case? Okay. And I'm just going to tell you, I wasn't in the jury room, so I don't know what the jury found most compelling or not. For me, as a lawyer from this angle, I didn't attend the trial. I didn't see the evidence presented, and it's just hard for me to get a full grasp on it. But there are court documents that give me some pretty good signs. Like, for instance, I read the complaint, read the answer, read the motion for summary judgment, which that's where you ask the court to grant you a win without having to go to trial. And both the sides argued that, submitted briefs to the court, things like that. The class certification order. These are all things that I've read that were part of the Missouri case to help me figure out what were they looking at? What did the jury look at in order to come to its conclusion that there had been an antitrust violation here? So let's talk about some of the things that were alleged and the jury considered. Number one, is that the argument of the plaintiffs was that sellers were, by paying cooperating compensation and by offering that they were paying too much in commissions. Okay. The argument of the plaintiffs, which the plaintiffs were sellers in that case, but the argument of the plaintiffs was that the sellers shouldn't have been required by the market forces, if you will, by the way the MLS works, by the way things generally worked in that area. I mean, as we know, probably other areas as well. That they, in a normal market or in another market, in other circumstances, without the rules as they are, they wouldn't have had to pay a buyer agent commission when the buyer agent didn't even represent them. They're essentially paying someone to be, their enemy in the transaction. Not necessarily an enemy. You know what I mean? You're paying someone who's not even looking out for your interest at all, and in fact is looking out for the interests in the other party on the other side of the transaction. Okay, and the sellers were saying that was not fair. That if the MLS rules were not written the way that they were, then they wouldn't be paying buyer agent commissions at all, and buyers would be paying their own agents. Okay, which would reduce rates and things like that. So that was kind of the argument that went ahead. So what were the kind of the underpinnings? Like, what were they really pointing at? Well, number one was the what I just mentioned, the rule, was it policy statement 7.2? I think it's 2G1 or something like that in the MLS handbook, but it's the unilateral blanket offer of compensation MLS, right? Another thing the jury considered as part of this process was that there's minimum commission rates set by firms. So firms in and of themselves setting rates for whoever is affiliated with the firm in order to take on a transaction. That was evidence that was submitted to the jury. There was a lot of evidence that we're not going to cover in detail today. I actually read an article in the Wall Street Journal this morning. The plaintiffs had to take out loans to fund this lawsuit. And one of the things that they had to fund was expert witnesses to talk about comparative market forces and talk about what a market might look like without cooperating compensation the way it is set up in the MLS book. And apparently one of the bills that the plaintiff's lawyers got as part of this case from one of their own experts was a bill for $1.7 million. So to give you just a small idea of the scope of the kind of evidence that was in this case, it's simply beyond what I can cover here today on a Mobile Monday, and also be able to take your questions and things like that. Oh, by the way, if you have questions, you can drop them into the comments on the Facebook Live. I'm doing this through a Zoom call, so I can't see them. But if you want to ask questions, we're going to leave plenty of time once I wrap up here to answer any questions that you may have. Okay. Another issue of evidence. Back to the expert witness. So, the expert witness or witnesses, I'm not sure how many there were or what exactly they talked about, but generally speaking, from what I could tell from the documents I read, these expert witnesses testified about how if there was no policy statement 7.2, if there was no mandatory offer of compensation in the MLS, then the market would look different. That the rates of commissions paid by sellers would be substantially lower. So, and I think actually the argument was that commissions all around would be less than what they are. I do know that these experts compared the commission rates in the United States, maybe to this market, specifically compared to other markets, some similar markets, in other areas of the world, and what agents in other countries make compared to agents in the United States. I do know that was part of the evidence. So one of the things the experts testified about was this issue that they called steering. And some of you may remember from real estate school the term steering. in real estate school, you probably talked about it more in a fair housing context, where you're not going to steer clients, to certain neighborhoods or certain houses based on their race or their religion, things like that. So, but the concept is similar in this case, where instead what they said was that the buyer agents who are part of the MLS would steer clients toward homes that had commission rates that the buyer agent wanted. That was part of the allegations and part of the evidence submitted to the jury. Okay. Some other facts that were alleged in this case, and I think will be in the case going forward. So far, I've talked mostly about the Missouri case, the Burnett case. Okay, there's another one that's been pending for a while in Illinois. Okay, very recently, very shortly after the Missouri verdict came out, another case was filed in Texas, and that Texas case is substantially similar to the Missouri case. Reading the Texas case this weekend, all I had on that was just the complaint. So this is just when the plaintiff is making allegations in Texas. They haven't been proven. There hasn't been a response filed yet. It's very early in that case. It's brand new. But some interesting facts that were alleged in the complaint in Texas was that only 0.5% of sellers offer a buyer agent commission below 2% in the Austin, Houston, Dallas, and San Antonio areas. So what they're doing is saying that because there's such, there's this floor of buyer agent commissions that nobody apparently really crosses, and then because of that, that's just part of the evidence that there's an antitrust problem. Okay. A large majority, 73% of agents, say they will not negotiate commissions. That's part of the allegations. I'm not saying that that's true or that they're going to prove that. But what I'm telling you is that they are using that allegation to, I guess I would say it this way. I practiced litigation before I stepped into this role, with primarily working with realtors every day. I did litigation. And I did that for years. And I never alleged anything in a complaint that I didn't think I was going to be able to prove, that I didn't have some evidence for, and put it that way. So if they're making an allegation, it doesn't mean it's true, but it does mean that they probably have something to go on, at least unless they really feel like getting sanctioned by a judge. It's a really easy way to get sanctioned by a judge, is to make a bunch of allegations in a complaint that you have no evidence for. In any event, so one of the allegations is that, a large majority of agents, 73%, say they will not negotiate their commissions. And then finally, another thing in the Texas case that is alleged in the complaint that I presume they intend to talk about, is that experts will be testifying that, those facts, together with the facts I've already mentioned from the Missouri case, like the MLS rule, things like that. They also, I guess, while I'm thinking about it, there was also part of the Missouri case where they talked about Article 16 of the Code of Ethics and Standard of Practice 1615 and 16-16. That was also alleged in there. And I understand completely, that those sorts of things are not things that you guys, as realtor members, necessarily have control over. Those are promulgated by the National Association. But interestingly, the National Association is not, at least not yet, a defendant in the Texas case. They were a defendant in the Missouri case, but they're not in the Texas case. But the Texas Association of Realtors is, along with other firms and agents and local boards, things of that nature. So I guess now that I've sort of explained what happened, the next question you might be asking is, what's next? NAR has been very clear that they are, going to appeal this, and they're going to appeal this all the way. And I think there's a real good chance this would get to the Supreme Court, the United States Supreme Court. What will happen? Don't know. Like the question I usually get when I mentioned that there'll be an appeal, well, what are the chances of winning? I have no clue. I really don't. It's very hard for me to predict that from this level. Do I think that there's a chance NAR will win at any level of their appeal? Of course, of course. There's certainly many arguments to make. You've heard many of them over the years. If you've listened to any of the antitrust statements from the National Association over the years, you know what the arguments are. You know the arguments for cooperating compensation, how it benefits clients, and things like that. And AR's put out a lot of things on that in the wake of the verdict. Okay. And so I don't want to minimize those things necessarily, because they may well win the day. For me, my purpose is today. I felt like there is an element missing of what actually happened in Missouri. All you see is this big number of, $1.7 billion jury verdict against a bunch of real estate companies and the National Association, things like that. For me, I just think it's important for you guys to understand the context of that case. But as far as arguments to the contrary, yes, they were made there. They're going to be made on appeal, and they may win on appeal. That said, I always tell people this story. For those of you who don't know, I spent my first year and a half out of law school working at the Court of Appeals in North Carolina for a couple different judges, Judge Hunter, and now his name's escaping me. It'll come to me later on. And Judge Thigpen. Sorry, Judge Thigpen, if you're listening, that's terrible. He was excellent. He was an excellent boss. I appreciated my time with him. In any event, so I worked at the Court of Appeals. I did for a year and a half. I did appellate work for years. Once I left the court in private practice. And there was actually a case I took to a jury trial, all the way through a jury trial in Johnston County, and all through the trial, I just thought I was getting the raw end of the stick. Like, I felt like I was getting home cooked by the judge there. Felt like it was unfair, and so I was like, all right, well, I feel like I have very good grounds for appeal. I mean, I felt very confident about winning my appeal. This is a case I had taken, from cradle to grave, essentially, when it came to, the trial, and then feeling like the trial wasn't being fair to me, and then taking it on appeal. Actually got a pretty good jury verdict in that case, but I felt like, we could do even better on appeal. So had success in front of the jury, figured I could take it to the Court of Appeals to get the rest of the rest of what I wanted out of that case, to get justice for my client. And we just lost. Not even one dissent, on a 3-judge panel. And it just stunned me. And it wasn't, listen, on the panel, this was a court I worked at. I knew the panel. I knew who these people were. And still, so it wasn't like strangers making it. I knew I wasn't getting home cooked at the Court of Appeals. not with the panel that I had. I just, I just knew it. And so it really made me think, well, was I inside my own head? No, I don't know. I had a whole midlife crisis after that. And, I'm over it now, but it's a good story in any event. All that is to say is that there's plenty of appeals in my life, when I did private practice appellate work, that I won, and won because and I was confident, that I was going to win going into them. Other cases that I lost, that I was confident I was going to lose. Right. So to me, it's too hard to tell at this point whether there's going to be a win on appeal or not. If NAR and these other defendants that this jury verdict was awarded against, if they win on appeal, then this whole case goes away. And if they don't win, then it basically means that the rules will have to be even more closely examined than they are right now at the national level. Those are all things that have a long way to play out. But the real issue, and what the focus of myself and the staff has been since the Missouri verdict came out, is giving you guys the information you need to make immediate changes right now, if that's what you choose to do. So let's talk briefly about that, and then I will get into the questions. I think that, number one, you can expect some forms changes. Okay, there are already really helpful part of our forms that would be if a similar lawsuit is filed here in North Carolina. There are things in our forums that I think will be helpful to show that it's not the same as Missouri or Texas. Okay. So, but you can look to see what, we're not going to be satisfied with that. Our job is to be as helpful as we can when it comes to forms and things like that. You can expect some forms changes. That's going to happen. As well as some changes to the standard policy manual, or the model policy manual. It's not standard, but the model policy manual from NC Realtors, things like that. Okay. So that's something you can do. There's also a whole bunch of things that I talk about on the FAQ website on ncrealtors.org. If a staff member could put that in the comment section, post a link to that if you haven't already, that'd be great. But the FAQ, I go into detail about a lot of things, but I think the biggest drive home for me, if you take away nothing today, is if you have internal firm policies about what commission rates you expect your affiliated agents to charge customers, I think you need to talk to your counsel. I'm not your lawyer, okay? I'm NC Realtors lawyer, and it's my job to assist them in the things that they do. But if you have a lawyer, then you need to make an appointment with them and talk about those sorts of internal firm policies in a real and meaningful way, because those sorts of policies were, in fact, submitted as evidence in the Missouri case. So that's something you're going to want to do. You're going to want to look at your training materials closely. There were training materials that were submitted in the Missouri case, also having to do with how to handle clients if there's a discussion about commissions. I think the big takeaway to me from the Missouri case was that, it's something that I have seen many times, talked about, but I think it's really time to just, really give it more practice than maybe you ever have thought about doing before. And that is just having frank discussions with your clients about what kind of commissions need to be paid, what kind of cooperating compensation needs to be offered, if any. So that's a conversation you're going to have on the listing side, and on the buyer side, you're going to have a real conversation about whether there will be cooperating compensation or not. And I think that, if there's not cooperating compensation, then making it clear to the buyer that the buyer, under our standard form buyer agency agreement, the buyer is expected to pay your commissions. Some suggestions also in the FAQ on the buyer agent side that I'll just briefly mention is, doing buyer agency on different ways, and if there's no cooperating compensation offered, for example, in a particular transaction, seeing if you can negotiate it, because it is possible to negotiate commissions. We just recently wrote a Q&A on that recently, actually, about how to negotiate commissions prior to an offer being made. But if it turns out that there's just not sufficient cooperating compensation offered by the listing agent, then just talk to your buyer about ways that they can pay for your services. And I'm going to say this, I think this is sort of lost in this whole discussion, but I believe wholeheartedly that buyer agents and listing agents have value. And if you don't believe you have value, then you're mistaken. You do have value. I think that the services that are offered are really indispensable. So really, I think if I could encourage you in one thing, it is don't undervalue what your value is to someone who is buying or selling a home. And make sure that your client understands that. Make sure that understand that commissions are negotiable, but at the same time, your time has value. And it's not just that your time has value, or I guess I would phrase it this way. It's not your time doesn't have value if you don't bill at an hourly rate. You could bill at an hourly rate. You can. That's totally permissible, whether you're a listing agent or a buyer agent. You can do it on a percentage. You can do it on a flat fee. You can do it on however you want to value your time, you can. And if you want to, change the way you give services based on what's paid, you can do that too. Nothing out there in this Missouri case, I think, limits your ability to value your time, sell your services, which are an important service. And a lot of people that I talk to who are lay people, understand the value of an agent's services if they have really gone through at least several transactions. They understand the value of what an agent brings. So anyway, just a little plug on that, and a little plug on, it's not all, the Missouri case may well concern you. It may well be shocking. And the uncertainty around it may be, disconcerting. But what I would respond to you with is that, it doesn't change who you are, and it doesn't change the value you bring to this arena. So just understand that. Just understand that it may well be. Listen. One of the things I do in this role is talk to agents on the hotline, and I do that 4 days a week. I will tell you, you guys are very creative. So I have no doubt that you you will find ways to adapt and adjust as necessary. So to me, this is not like some kind of sad conversation, but it is a serious conversation that I hope is helpful for you. In any event, so I think that those things, if I was going to recommend anything just for today on this Mobile Monday, those are the things I would suggest. On the listing agent side, buyer agent side, you need to have a real discussion about commissions. And if you have an internal firm policy of some kind, even if it's a franchise policy, talk to your franchise, whoever the franchise lawyer is, talk to them, and talk to your lawyer too. All right, so let's get into some questions. And the first question is, do you know if the Missouri agency agreements have a similar cooperation paragraph as we have in the NC listing agreement? I don't know anything about the agency agreements in Missouri. Anything I would have to say about that would be speculation. I can tell you this: it wasn't the evidence that was discussed very much. I think agency agreements can be and it may well be just the way the Missouri agency agreements are structured. Maybe that's why they weren't really a factor in that case, at least not when it came to what the plaintiffs in that case were really arguing about, if that makes sense. That's not to say that they're not important. I do think they're important. All I can tell you is that in the Missouri case, they didn't seem to be a big factor as far as what the plaintiffs were relying on to get their case across the line. And it wasn't something that I saw very much on the defense side. But I will say this, just from the way that I can access the case, there's only a limited amount of the defense material that I could see. And that wasn't really an argument that seemed to be made very prominently. Now, why that was, I don't know. Would it be an argument that I would hope to be made here if one of these lawsuits came to North Carolina? Yeah, I would hope so. Mostly because in our standard form agency agreements, there is lots of helpful language in there for listing agents to discuss commission rates and cooperating commission rates with their listing agents, and for buyer agents to talk about the fact that they will seek cooperating compensation, but that the buyer truthfully is going to owe them if there is none. So to me, those are important factors, and I think that they would potentially be evidence in a North Carolina case if one comes here. But hopefully, if you learn nothing else about the discussion today, it would be one small piece of the pie as far as the entire case goes. Another question is, why did National Association of Realtors word the MLS compensation rule to say, in order to list the MLS, broker must provide compensation to cooperating brokers, instead must state compensation, if any, to cooperating brokers? Very good question. Very good question. And then the follow-up question to that is, why would a lawyer allow that to pass muster? Yeah, I think that's really interesting. I think I guess we could get further in history here. Some of you would know this history better than I would. But, the National Association had an issue with, there's a wave of antitrust at the National Association of Realtors in the 1950s. And my understanding of that case, I haven't read it in depth, but my understanding of that case was that, the National Association was setting commission rates at the national level. So there was that case. Then years ago, there was some similar antitrust allegations regarding seller subagency. And then out of that, in the 1990s, is when this rule was adopted about cooperating compensation. I mean, in the 1990s, I was playing soccer in high school and only looking to go play soccer in college and did not know that antitrust existed. So I don't know the history of that case very well, other than what little I've read about it. But in any event, that's where this rule came from. Why they worded it that way, I do not know. I do, but I mean, I will say this. I think that it's always been the case that you could put, for an offer of cooperative compensation, you could put in $1. Or I've seen some places that say you could put in 0, but I'm not sure that would comply with the rules. It seems like there's not necessarily agreement on that. I don't know. I haven't seen any official guidance on it. But in any event, what is the real difference between $1 and 0? I'm not sure. In my mind, personally speaking, I just don't think there's that much of a difference. But functionally, certainly, I'm sure, buyer agents wouldn't think there's functionally very much difference between $0 and $1 offered for cooperative compensation. But it's always been the case that you could do that. It's just that people didn't do that. And that was part of the evidence that was, submitted in that case, and part of the facts or data that, the experts used. And mind you, NAR had their own experts. They did. I have no doubt they're probably very well paid experts. But all I can tell you is that when it comes to what the plaintiff submitted and what the defendant submitted, the jury came back and awarded $1.7 billion in 2 hours. So to me, that's an indication, at least for that jury, of what they felt the weight of the evidence on both sides was. And it was not in the National Association's favor or the firm's favor, because, let's not forget that there are real estate firms who were still defendants in the case at that point. So next question we have is, why do you think NAR was not named as a defendant in the Texas case? I don't know. That's a real good question. And it may well, speaking as someone who does litigation, there could be a host of reasons. I would guess that there's some kind of strategy there. There is a reason why they wanted to do that. It may well be that, it was a junkyard dog they just didn't feel like messing with. They knew that, the chances of, there's a lot of defendants in the Texas case. I'm not sure what the exact number is, but it's got to be at least 20, 25. It's local boards, it's real estate firms, real estate brokers. Like, I think there's some individual brokers named in there. I'd have to double check that, but they're at least mentioned, even if they're not specifically named as defendants. The state association, local boards, things like that. So it may well be that they didn't want. Interestingly, the Missouri State Association of Realtors was not named in the Missouri case. So, and I don't know what the strategy for that was either. In any event, it doesn't look like there's any other questions. If you need any links or anything like that, they should be in the chat. But if they're not in the chat, or if you've missed them, or you just need more help or guidance on this, there's always the legal hotline at NC Realtors. The phone number and questions for that should be in the chat also, I think. But the email is legalhotline@ncrealtors.org. And then you can call the main office in Greensboro. They will transfer you over to the legal hotline department if you have any questions. Anyway, thank you all very much for attending and for hopefully not falling asleep too much. And I hope you have an excellent day.